Welcome to competition law course and dear learner and viewer. Today we are going to discuss the extraterritorial application of the competition law in India, and or we can say we are going to discuss the transnational competition law under the Indian Competition Act of 2002. Dear learner and viewer, we happens to have the two previous lecture on the aspect of the extraterritorial application of the competition law in India. We have taken note of the Indian Constitution. We have taken note of Article 38, 39 of the Indian Constitution. We refer to the passing of the Monopolies and Restrictive Trade Practices Act of 1969. We have also tried to have a critical appraisal of the section 14 of the Monopolies and Restrictive Trade Practices Act vis-a-vis the power of the Monopolies and Restrictive Trade Practices Commission in respect to inquire and investigate the cases of the anti-monopolistic tendencies, restrictive trade practices, and unfair trade practices in relation to the goods, services, and parties in matters of the production, control, supply, and distribution of goods in India. And we try to see that how the Indian competition law, which was started by the Monopolies and Restricted Trade Practices Act of 1969, was fall short in the context of the new sets of the economic reform which has been ushered in 1990s by way of liberalization, privatization, and globalization, which has changed the entire goalpost of the Indian economy from being the mixed economy to have a centralized marketized economy. And the new prescriptions of the economic reforms required that the old approach of the command and control kind of an economy and the licensing Raj should be done away with, and it should herald new free market principle, and which can take a greater stride in the sense of the competitiveness in India to meet that end of the economic liberalization which has spread its tentacles in the Indian economy, the structure. The India required a kind of a new law, and the requirement of a new law was also felt, as we have discussed in the previous lecture, the two major cases on the point wherein the power of the power conferred under Section 14 of the Monopolies and Restrictive Trade Practices Act of 1969 vis-a-vis the power of the Monopolies and Restrictive Trade Practices Commission in giving effect to extraterritorial jurisdiction in relation to Alkali Soda Manufacturer Association case, and as well as the All India Float Glass Manufacturer Association case, the ANSEC case, or the Haridas case as it is known as. This both were decided by the Supreme Court of India, and Supreme Court had an occasion to interpret substantial question of law in relation to whether the Monopolies and Restrictive Trade Practices Act of 1969 and the MRTP Commission, for that matter, are inherently endowed with the power to have an extraterritorial application of the anti-monopoly or restrictive trade practices or unfair trade practices. The Supreme Court answered it in a negative term, and Supreme Court have very categorically ruled out that neither Section 14 of the MRTP Act nor MRTP Commission have the power of extraterritorial jurisdiction. Supreme Court goes on to record further that not only that the Section 14 does not have the power, or the MRTP Commission does not have that power of extraterritorial application or transnational application of competition law, but the US antitrust doctrine, the effect doctrine, is not recognized under these provisions of under the provisions of Section 14, and it is not inherently endowed to MRTP Commission. That's why we see that a kind of a scenario which has been created, which demanded a kind of a reform in the competition law, and to see that the competition law India must have a kind of a vision to have the transnational application of the competition law extraterritorial application of the competition law and the myopia which the MRTP Commission has suffered on the issue of the extraterritorial application of the competition law needs to be diagnosed and corrected. In that way, the government of India, in line with the new economic policies, happened to constitute a very high level committee on competition policy and competition law to advise the modern sets of the law and to redesign and restructure and have a legislative upgrading of the competition law, moving from the anti-monopoly concerns or anti-monopoly vision to the competition law as such. And then this committee has submitted its report to the government of India in 2000, and the net effort and the recommendation which have undergone and which has been meticulously taken by the high level committee to look into the promises and the pitfalls of the MRTP Act and the need to have a new sets of law to suit the needs of the modern economy and the modern competition and the marketized economy was submitted to the government in 2000. And finally, looking at the recommendation of the commission and the report, the government of India have passed the Competition Act 2002, which was enacted for the purpose of providing a competition law regime which can meet and suits the demand of changed economic situations and scenario in India, not only in India but abroad and the global level. So, in the context of the new economic policy and the new paradigm which the Indian economy has undergone, it tries to enact a competition law in 2002, and it supplanted the MRTP Commission to a new commission in 2007 that is called the Competition Commission of India, which was established an statutory body in 2013. And then we see that this Competition Commission of India have conferred a broad mandate to see how the competition law and the Competition Act of 2002 happens to be a great success, along with the desideratum which has been found in the MRTP Commission in matters of extraterritorial application as reflected into the Alkali Soda Manufacturer Association and All India Floored Glass Manufacturer Association's case, the ANSAC case or the Haridas case. That kind of a desideratum, that kind of a vacuum which was created, that has been removed, that has been filled up by giving extraterritorial application of the competition law. And the Competition Commission of India happens to see that how it can apply the Indian competition law in transnational context and extraterritorial context. And for that, we have to refer to the provisions directly dealing with the extraterritorial application or the transnational application of the competition law, which has been laid down under Section 13 of the Competition Act 2002, and it contains the extraterritorial jurisdiction of the Competition Commission of India. Therefore, the Section 32 of the Competition Act is seen with a great hope, and we need a kind of an interpretation of Section 32, and we will find that how Section 32 happens to be the heart and soul of promotion of transnational competition law, as well as the extraterritorial application of the competition law, and how the Competition Commission of India, under its statutory mandate conferred by the Competition Act 2002, happens to exercise extraterritoriality or extraterritorial application of the competition law and the transnational competition law. We will see all those cases. We will see that what action has been taken, what the CCI, the Competition Commission of India, has done it in its right earnest, and how the government of India is going to apply the Competition Act 2002 with extraterritorial jurisdictions and as well as in the transnational matter, and to what extent that the Competition Act or the Competition Commission of India happens to be successful in heralding a series of memorandum, series of engagement, series of diplomatic channels, so that the sense of the national competition, the regional competition, the global competition, which is the basic ethos of the Competition Act 2002, can be satisfied, can be fulfilled, and can be achieved to a great extent. What we see, dear learner and viewer, Section 32 of the Competition Act 2002, in a very clear words, gives two powers. And the first power happens to be that the competition commission, even if happens to be anti-competitive practices has taken place beyond the territory of India or partly to such agreement which is outside India, therefore it's very clear that in both the cases that the effect doctrine means the conduct, the anti-competitive conduct, that is important, that where it has actually taken place, and we will try to see that the anti-competitive conduct, whether it was discernible, manifested in Indian jurisdiction or some other jurisdictions also. So in that way, it has two range of the power to address the issue of extraterritoriality, and what we can say, not only the effect doctrine but the implementation doctrine. It tries to see both the doctrine, though it does not expressly mentions the name of these two doctrines. Nonetheless, if we carefully peruse Section 32 of the Competition Act, we find that it encapsulates not only the effect doctrine, but it also incorporates the implementation doctrine in giving effect to the extraterritorial application or the transnational application of the competition law. With this, we will try to see as to what is exactly contained under Section 32 of the Competition Act, and for that we have to take a kind of a basic reading and browsing of the section, because that section happens to be a cardinal section of a pivotal significance, and we have to chisel out that as to how Section 32 tries to incorporate the extraterritorial and as well as transnational competition law. Section 32 reads out, the Commission shall, notwithstanding that an agreement referred to Section 3 has been entered into India, or any party to such agreement is outside India, or any enterprise abusing the dominant position is outside India, or a combination has taken place outside India, or any party to combination is outside India, or any matter or practice or action arising out of such agreement or dominant position or combination is outside India, then what we see that the enumeration of Section 3, Section 4, Section 5, Section 6 of the Indian Competition Act, which tries to encapsulate anti-competitive practices, anti-competitive behavior. It tries to encapsulate regulation of combination. It tries to encapsulate the abuse of dominance, and then all kinds of the anti-competitive concern which has been reflected under the Indian Competition Act under Section 3, Section 4, Section 5, Section 6. It gives a broad coverage of the anti-monopoly or restrictive trade practices or unfair trade practices, and a combined reading of Section 3, Section 4, Section 5, and Section 6 of the Competition Act gives a total image and the portrayal of the competition concerns of various sorts and kinds. And Section 32, while saying that the Commission shall, means that the Competition Commission of India has a mandatory duty and power and function, and it says notwithstanding that, meaning thereby the one case happens to be that anything which has been referred to Section 3, it tries to take all kinds of anti-competitive concerns and relating to combination, regulating to abuse of dominance, relating to anti-competitive behavior, relating to cartelization. Then what Section 32 tries to lays down that have what is the nature and ambit and function of the power. It simply says that have power to inquire in accordance with the provision of, again, what has been contained under Section 3, under Section 4, under Section 5, under Section 6. Its replica and the mirror image is being carried out under Section 19, Section 20, Section 26 and 29 and 30, meaning thereby what has been the substantive provisions of the competition law which has been underpinning the Competition Act of 2002, be that Section 3, be that Section 4, be that Section 5, be that Section 6, the procedural version of the application of that law, competition law, or these are the substantive competition law happens to be Section 3, Section 4, Section 5, and Section 6, whereas what we find that the procedural competition law happens to be Section 19, Section 20, Section 26, Section 29, and 30. So, in a way, the substantive part of the procedural law, substantive competition law, and the procedural competition law have to be studied in conjunction with to understand that what is the range of power, what is the ambit of the power, what is the scope of the power which has been conferred by the Competition Act under Section 32, and how it tries to repose that power and confidence on the Competition Commission of India, which has a statutory and a mandatory duty to look at all the violations of Section 32, Section 3, Section 4, Section 5, Section 6, along with its procedural version of Section 19, 20, 26, 29, and 30 in giving effect to any kind of the any kind of what we can say that the Indian law happens to choose a very carefully it has chosen what it has chosen in place or in equivalence to the effect doctrine of the United States antitrust law. The word happens to be an appreciable adverse effect on competition in the relevant market of India. So, if we try to understand whether the effect doctrine of antitrust law of the United States has been recognized per se or express verbis, then we have to see what is contained under Section 32 that likely to have an appreciable adverse effect on the competition in the relevant market of India, and then the Competition Commission of India can pass such order as it deems fit. Is again the same power, is a kind of an omnibus power, it's a kind of a blanket power, it's a kind of an unbridled power, that whatever power has been conferred in relation to Section 3, Section 4, Section 5, Section 6, and Section 19, Section 20, Section 26, Section 29, and 30, it has, in addition to that, it is under a duty, and it has been empowered to pass such order as it may deem necessary and fit in accordance with the provisions of this act. Therefore, what we can conclude, dear learner and the viewer, that the modern competition law in India, which happens with the Competition Act 2002, through its instrumentality and the administrative and the statutory authority of the Competition Commission of India, have how beautifully tried to come out of the pounds and shells of Alkali Soda Manufacturer Association's case, known as ANSAC case, or All India Float Glass Manufacturer Association's case and the Supreme Court's ruling in a very categorical manner that the Monopolies and Restrictive Trade Practices Commission as well as Section 14 does not contain any kind of a power on transnational application of competition law and extraterritorial application of the competition law vis-a-vis vis-a-vis what we can say that the section 14 and the MRTP commission it does not recognizes the effect doctrine of the antitrust law of the United States. But if we look at section 32, all those lacunae which has been pointed out in these two cases and the existing law on the competition have been carefully been removed by the enactment of Competition Act 2002 in matters of section 32 and the powers and functions of the Competition Commission of India to take up the cases and have advanced enforce competition law. Not only it can enforce and execute, but advanced competition remedies, which its blanket and omnibus power to pass such order encapsulate the large range of the competition remedies can also be advanced by the Competition Commission of India vis-a-vis the extraterritorial application of the competition law and the transnational application of the competition law. With this, dear learner and viewer, we will conclude and say that now we can say with great sense of confidence and appreciation that the Indian Competition Act 2002 express verbis incorporate extraterritorial jurisdiction as well as the transnational application of competition law. With this, I thank you and I wish you a happy learning.